Morning, Mr. Chairman.
Good morning.
Madam Chairman, members of the committee. I'm not George Hofstetter. George, unfortunately, sends his apologies to the committee. He was called on an emergency meeting that he had to be in Los Angeles. So he asked if I would pinch hit for him. So I will do my best to do my best imitation of George Hofstetter. My name is Tim Yarian, and I am today representing the Association for Los Angeles Deputy Sheriffs. We are the largest Deputy Sheriffs Association in the state and in the nation, actually. And we're here to talk about the governor's portion of the initiative, not the juvenile part, since that's the part that we're mostly involved with. To begin, I think we need to put the governor's initiative into proper perspective. And that means we need to look at what's been happening with California's crime rate. Data released by the FBI shows that post-public safety realignment and post-Prop 47, the crime rate has significantly increased. Among the 25 largest cities, 3 in California, San Francisco, Long Beach, and Los Angeles, had the 3 highest increases in per capita property crime rates during the first half of 2015, the most recent period for which numbers are available. In San Francisco, the property crime rate rose by 667 cases per 100,000. The increase in Long Beach was 146.5 property crimes per 100,000. In Los Angeles, just a tad less, about 144.9 thousand. The increase in violent crimes was not quite as sharp. Sacramento led the nation with an uptick of 77 violent crimes per 100,000. Los Angeles was third with a rise to 54.1 per 100,000, and Long Beach fifth with 45.8 more violent crimes per 100,000. The point I'm making with this is that the people that have been released from prison due to realignment, due to Prop 47, we're seeing a significant increase in crime. We're not solving the problem at the state level. And this initiative invests everything in CDCR to make the situation right. And to date, they haven't done that. They have not accomplished. There is no track record which suggests that suddenly, magically, we're going to turn around and all these people coming out of state prison are suddenly going to be rehabilitated and be good citizens. So that's the first concern that I have. The claim is widespread around California by law enforcement officials that the combination of realignment and Prop 47 has led to increased crime. To support this, the Orange County Board of Supervisors did a study and found that about a quarter of the 8,000 felons released into the county by realignment were convicted of another crime within a year after their release. Just over a third reoffended within 2 years. The data suggests rehabilitation efforts are falling short, and the recidivism or revictimization carousel continues. To be sure, Governor Brown did not cause the current spike in crime. In fact, he's done a very good job, in my opinion, in managing a difficult situation created by our overcrowded prisons and the federal courts. But proposing to release more felons at a time when California's crime is at an all-time high, when California's police, sheriffs, probation officers, and district attorneys are literally overwhelmed, when failure to significantly curb recidivism at the local level has led to more, not less crime, is simply put not a good idea. In addition to breaking faith with thousands of victims, the governor's proposal also fails short on substance. There is absolutely no evidence to suggest that inmates released early will be less likely to recidivate, as he suggests. As I said, CDCR's track record has been dismal, and there's a similar failure at the local level. Prop 47, for example, promised that money saved by reducing prison costs would be spent on rehabilitating drug addicts who victimize our communities. Less than a year after Prop 47, drug rehabilitation have failed. In Los Angeles, since the promised savings from Prop 47, only 73 of the 2,200 plus drug offenders have entered into court-ordered treatment. In a dead honest assessment, Los Angeles City Attorney Mike Feuer suggested almost no one has gotten anything close to meaningful drug rehabilitation, and we've prosecuted thousands of cases. The governor's initiative proposes more of the same. I'm going to close to allow the others to testify, but I want to make a couple of comments. I want to talk about first nonviolent offenders, because we think, or it's being purported that the people that are going to be released are people that do not have violent histories, and nothing could be further from the truth. The truth of the matter is, when the parole board considers releasing someone on parole, they only look at the commitment offense. So you can be a person that had a very serious, violent felony as a prior, but it's not considered for purposes of parole. So to say that this person is a nonviolent offender, when most of their life history suggests maybe that's not the case, is something we need to take a very close look at, because we're not necessarily going to be releasing those not violent. And it's a little deceiving and misleading to suggest that they are. Now, I'm all supportive of efforts to rehabilitate people in prison. That makes our jobs as law enforcement officers a lot easier. But there's a long gap between what happens in prison and what happens on the streets. And let me give you an example. When you're in prison, you're in a very structured situation. You're not going to be influenced by drugs and alcohol so much. You're going to be in a situation that can be relatively controlled, and you can do the right things to get out. When you return to the community, all the constraints that you had in prison, all the structure you had in prison no longer exists. You're going to be subjected to temptations from alcohol, drug treatment, gang influences. These are the kinds of things that are real-life things. The governor's initiative does not prepare us for that. I will tell you in Los Angeles County how prepared we are. We're down about 1,500 deputy sheriffs right now. We're down over 2,000 probation officers over now. If this passes, we're going to be banking caseloads. Instead of supervising these releases from prison, we're just going to have to bank them because we don't have the personnel and manpower. Now, Senator Leno's back. Welcome, Senator Leno. I want to, one of the things I want to throw out here is in managing the prison crisis, one of the best responses the legislature had, and I'm going to credit Senator Leno for being a driving force on this, was SB 678. And we realized we needed to, at the front end, to try to reduce the inflow of prisoners to state prison. And so we had an intensive supervision program to deal with the people that we felt were the highest risks, to keep them from reoffending, from re-victimization, from recidivating. And it's been pretty darn successful. But we don't have a similar institution on the tail end. So when we do all these wonderful things in state prison and we put them out in the community, there's going to be no support. The drug rehabilitation effort that Mr. Feuer talked about, that's an example of a failure. We don't have the institutional ready, and it's not something we can just wave the wand and say, okay, we'll just create 2,000 deputy probation officers or 1,500 deputy sheriffs or this program or that program to make sure that there's support after they get out of prison, because that's where they're going to fail. They don't fail in prison. They're going to fail after they get out of prison. And we're not prepared to deal with that. And unless these questions are answered, we shouldn't go forward until we've addressed this problem. This should be a legislative issue. This shouldn't have been gone to the voters without the input from law enforcement. We didn't have any say over this. This was just presented to us. We think it's a bad idea. We think some of the concepts are good and supportable, but I think we've got a long way to go if this thing is going to work. With that, I thank you for your...
Thank you, Mr. Yari.
Madam Chairman, Mr. Chairman, members of the committee, thank you so much for providing me with this opportunity. My name is Mark Klass. I'm the president of the Klass Kids Foundation, and I'm also here in opposition to the governor's add-ons to the Juvenile Justice Initiative. I first became acutely aware of the limitations placed on crime victims in the aftermath of my daughter Polly's 1993 kidnap, rape, and murder. Since then, I've worked with legislators, victims' rights organizations, police, and prosecutors towards a day when victims achieve equity with violent felons in the criminal justice system. California has a proud victims' rights history. We have created a body of work that protects crime victims, allows them to retain dignity and respect as they seek justice, and feel safe after justice has been achieved. We have further ensured that criminals are held accountable for their crimes. If the governor's so-called Public Safety and Rehabilitation Act of 2016 is passed into law, the blood, sweat, and tears of generations of crime victims advocates will be ground underfoot like an immigrant at a Trump rally, as violent criminals are released onto our streets and into our neighborhoods. The governor has said that any felony not included in the paltry list of 23 violent felonies defined in the criminal code would be a nonviolent felony for purposes of his initiative, because the term nonviolent felony offense is not defined in the initiative or elsewhere in California law. In 1982, the voters enacted Proposition 8, the Victims' Bill of Rights, which defined and listed serious felonies. While many are not on the violent felony list, perhaps they should be. A partial list of the crimes that are not technically considered violent, so therefore qualify as non-serious, non-violent offenses eligible for early release in the governor's initiative include, and I'm going to be a little bit redundant here, but for a purpose: human trafficking involving forced labor or services, human trafficking involving sex acts, obscene matter, or extortion, human trafficking involving a minor and commercial sex acts, pimping, pandering, transporting or providing a child under age 16 for the purposes of a lewd act, or the abduction of a minor for the purposes of prostitution. Now, this partial list that I just mentioned also obliterates Proposition 35, which had the support of 81% of voters when it passed into law in 2012, and determined that human trafficking is a crime against human dignity and a grievous violation of basic human and civil rights. I'm very proud to be a small part of a movement that has helped to cut California's violent crime rate in half since my daughter was kidnapped, raped, and murdered in 1993. However, according to a different matrix than has been mentioned already, the FBI's preliminary uniform crime report for 2015, in California, violent crime was up 12.9% during the first 6 months of 2015 as compared to the first 6 months of 2014. This represents the first significant rise in violent crime in more than 2 decades. The lessons of the past should steer us toward ensuring lasting legacies for generations yet to be born. Instead, they're being ignored as future generations become guinea pigs for a social experiment that is doomed to failure. My daughter's killer successfully completed rehabilitation and job training programs, and in fact was given a job that paid him $16 an hour immediately upon being released from prison after spending only half of a 16-year sentence for his second kidnapping. Yet 3 months later, my daughter was dead. He had told cellmates that he was going to avoid AIDS back in 1993 by getting a young one. So the kidnap, rape, and murder of my child was this particular individual's definition of safe sex. I just want to make sure we all understand the people we're talking about here. Now, this may sound harsh, but ask yourselves how you would feel if your child, your sister, or your mother became the next victim of a remorseless psychopath in a world that releases dangerous criminals onto the streets as violence again spirals out of control. Thank you for your time.
Thank you. Did you?
Thank you. I'm just here to answer questions.
Okay. Thank you. Are there any members with any questions?
I have some questions. I was reading the Daily Journal, and I noticed that there was a quote in here, and the quote is, "The list of crimes opponents are peddling is a deliberate mischaracterization of 667.5, which includes catch-all language, saying that anyone who inflicts bodily injury or uses a firearm has committed a violent crime and therefore is completely ineligible for consideration under the initiative. That came from Dan Newman, Brown's campaign spokesman. Can you respond to that for me?
Robert?
Sure. Well, let me say that those enhancements only apply if that specific section is pled and proven that's listed in 667.5C, and there's a lot of limitations on pleading and proving that. But even the governor has admitted that we're right. This is a quote from Dan Walter's article in the Bee from May 23rd. It says, quote, "The California District Attorneys Association, which opposes the measure, assumes that parole would be possible for any felony except the 23 crimes listed in Penal Code Section 667.5C, such as murder, that are deemed particularly violent. Thus, it would make dozens of crimes that most of us consider to be violent parole eligible, including assault with a deadly weapon, soliciting murder, intimidating or harboring a crime victim or witness, resisting arrest that injures a police officer, violent elder or child abuse, arson with injury, human trafficking, and several forms of manslaughter." Dan Newman, a spokesman for Brown's campaign, confirmed that the association's interpretation is correct. So that's the governor's spokesperson saying that the CDAA is right in its interpretation that a lot of what most people would consider are violent offenders would be eligible for parole just because the offense doesn't qualify under the violent list under 667.5C.
As a follow-up, how would this work in the context of something like human trafficking? So what I'm really thinking in terms of is, where are we today, and if this passes, where will we be tomorrow in terms of how much time someone would serve?
Well, none of the human trafficking offenses, even though they're quite serious, are on that 667.5C list. So you could take an example of, the human trafficking offenses are 236.1, which is human trafficking a minor or human trafficking for sex, Penal Code Section 267, which is abduction of a minor for prostitution. A lot of the human traffickers also are repeat offenders. They've been in and out of prison. So you could have a human trafficking person convicted of a 267, abduction of a minor for prostitution, with a strike prior. They used a knife during the commission of the offense. A judge would sentence that person to 10 years, 4 months. That would be the sentence the judge imposed. Under this initiative, that person is eligible for early release after serving only the base term, which even if it's an aggravated case, the base term is 3 years. And another important part is they only serve half of that. So they're eligible for release. Even though the judge sentences them to 10 years, 4 months, they're eligible for release after serving half of 3 years, essentially 18 months.
Thank you.
Okay. Are there any other questions? Mr. Leno.
Thank you. I'm glad I got the end of Mr. Yarian's presentation. I was here for Mr. Klass, and I'm sorry I missed some of the earlier ones. I was in another committee casting some votes. Where to begin? I think just to underscore, because I recognize this will be an ongoing debate as we move to November, but underscore, as you accurately said, would be eligible for. So I think we can all imagine some of the worst of the worst of the worst, but to suggest any presumption that they're going to be paroled, I think, is a far step. So I don't want to overlook the fact that this is just about eligibility and that there will be a consideration by a court of all of the facts, and that to fan any flames of fear, I think, does the entire conversation a little bit of injustice. I did want to ask the district attorney a question, if I could. We had heard some comments made by the proponents, in particular by Mr. Guzman from the National Center for Youth Law, with regard to some statistics as to how direct filing is used today. You probably heard some of them?
Yes, sir.
Okay. Is there debate about whether that is accurate or not, or do we recognize that, in fact, there is a disproportionate use for those from ethnic communities?
we disagree strenuously with the numbers that were advanced by Mr. Guzman in his presentation. You were not here, Senator Leno, and in our presentation I referenced the fact that with regard to the juvenile aspect of this initiative, there would have been a great divide among CDAA. Many of our members would have either supported the proposal to allow judges to be the ones to decide whether to bring juveniles up, or we would have had a number of our electeds go neutral. There was a debate about that. Even though it was an initiative that was passed by the voters, I think a number of our members would not have vigorously contested that aspect of the initiative. And we've spoken with some of the proponents of that part of the initiative and told them as much. And frankly, we think they bought a pig in a poke by allowing the governor to cannibalize their initiative and put this much more nefarious and dangerous initiative on something that was, in our view, more benign, certainly.
And I appreciate that has been an opinion and well determined by the courts recently. Can you give me, since I missed your presentation, what you think some of the facts are with regard to direct filing, how it is used? So there's no recognition that there's any disproportionate use of it?
Senator Leno, it varies from county to county as to how the determination is being made. I can only tell you what takes place in our county. We are very, very deliberate, very few juveniles, and I am somewhat ashamed to say Merced County has the unwelcome distinction right now of being the #1 county in the state of California for homicides at 10.9 per 100,000 people. Again, I would note down from the 34 per 100,000 people in 1980. But we make that determination very deliberately and very soberly, and it is only obviously for the most heinous, most violent crimes that have been committed. I have the final determination on that, and generally, if they're younger than 16, I'm not going to consider it, and we're going to look at it on a case-by-case basis. Many of our colleagues, as I've indicated, are not opposed to the idea of allowing judges to ultimately make that decision again. There is a split among CDAA, but I could not comment on the process for each of the DAs in all 58 counties as to how they make decisions on who to bring up.
Sure. No, it's heartening to hear you describe how you make use or not use of direct filing in your county. I don't want to put words in Mr. Guzman's mouth, especially since he's sitting right in front of me, but I would imagine when he said, I think it was 4 times greater likelihood, that he was talking about statewide numbers, not any particular counties. So are you familiar with statewide figures?
No, sir.
Okay. All right.
And again, that is certainly not why I am here. I do not oppose that aspect. As the district attorney in Merced County, I do not oppose that aspect of the initiative. I am vehemently opposed to the parole and early credits provisions.
And one response to your comment, Mr. Yarian, with regard to how this has made its way to the ballot and why don't we do things here in the legislature. And though we agree on some things, and thank you for your support of recognition of the success of SB 678, our community corrections effort that we all work together on and have now seen such positive results. But I've been here long enough to recognize and experience that, unfortunately, stakeholders do get entrenched, and we do try to do some reforms here. And the reforms, and I'm not going to speak to anything very specific right now, get stopped legislatively, and that's when things make it to the ballot. I guess I could get specific enough. Prop 47, if we'd actually accomplished our work here in the legislature, 47 wouldn't have gone to the ballot. So I think these reforms, which we now will have a difference of opinion on, do go forward to the ballot because we get stymied here in the legislature and we don't find the compromise that we're looking for. So that's how I see these things happening.
And I understand that. I think the question I would have is, this wasn't even tried first and failed. So this was brought out in the middle of the night, got an amend. When the governor was Attorney General before we dealt with realignment. He brought all the law enforcement groups in, and we talked about it extensively while he was still Attorney General. He didn't do this with law enforcement. He didn't do this with the district attorneys. He just dropped this, and without understanding all the consequences. And one of the things the legislative process does, it's not always about success or failure, as you know. It's sometimes we find out problems and issues that we haven't seen. And the whole process that we're doing here gives us much more information so that people can have a much more balanced decision. This wasn't done, and I think what we're going to have is when you talk about having reform on reforms, we're going to end up, if this passes, doing a lot of reforms.
Thank you.
Okay. Mr. Glazer.
Thank you, Mr. Chairman. I'd like to thank the proponents and opponents for being here today. I know this is a newer process that we go through now with measures that are submitted for the ballot. It's an interesting one to participate in. Certainly, after hearing the testimony today, I'm left a little baffled, and I'll explain. But we do know that enacting laws through initiative is not necessarily the best way to do our business because there's a lot of unintended consequences. And even though we know that there's difficulty in moving things through a legislative process where there are people with many different views, that there is great advantages in being able to correct mistakes or oversights as policy progresses and lessons are learned. Certainly the thing that strikes me about the conversations that we've been having this morning is this issue of the definition of nonviolent offenders. And while my colleague makes a good point about eligibility for rehabilitation doesn't mean that they will, it worries me when a measure is going to be presented to the voters that uses that term nonviolent offenders. In fact, it's in the ballot summary prepared by the Attorney General. And there's an implication when that language is used to most people that is different than what's being suggested by those who have testified before us today. And it's troubling. And I'm interested in hearing from the chair or from staff a couple things. First, did we invite the governor or the governor's representative to participate in this conversation today? Secondly, I don't like to hear the explanation from the proponent as coming through newspaper stories or quotes from spokespersons. That's not a healthy conversation that focuses on the facts. And I think that we would be best served that if the governor's representative was not invited to hold another hearing where they are asked to participate so we can get clarification on this very important question of definition of what's so-called a nonviolent offender. And if the governor or his representatives decline to participate in that review, which we are now obligated to undertake, that we ask them to provide written testimony that would refute or affirm the assertions that have been made in regard to what crimes would be eligible or not should this measure pass the voters. I know that I have been frustrated, and many people on this panel have been frustrated that in the course of an election campaign for an initiative, certainly one that's likely to be on the ballot, filled with maybe up to 20 or more different initiatives, that there is very little opportunity for dialogue and conversation and to dig down into some of these most very meaningful impacts that measures may have. And it certainly doesn't come from a lot of the misleading advertisings that are paid for by various interests. And we have an obligation to do everything we can to make sure that voters get a clear picture of what it is that they're voting on. And as difficult as that may be in our election process, I think it's incumbent upon us in the legislature to do our jobs as well as we can to provide that information so that people can be as informed as they're able to be. And I think this session today has been helpful and productive and insightful. I hope, given some of the serious points of confusion, though, that we wouldn't stop at this point in time and that we ask for clarification from the proponent of the measure, in any fashion in which he would be comfortable, and that we continue this effort to inform prior to this election, if it is to appear, so we can hope to have the most thoughtful decisions made by our community. Thank you.